Right, well, good afternoon, everyone, and welcome to what's been termed a masterclass in AI governance. I think what we're trying to do today is to focus very much on practical ways in which organizations should think about how to provide governance on AI to really make sure that the right things happen in what is this interesting new technology that in many ways has a lot of things in common with previous types of technology, but also has a whole series of ways in which it is new and unique. Now, when we think about governance, we strongly believe that governance is about two things fundamentally. One is making sure that good stuff happens, and second is making sure that bad stuff doesn't happen. The main focus of today is going to be more on the latter. We gave a couple of presentations yesterday, which I'm sure you can find on YouTube, where we talked about making good stuff happen with AI. But the focus today is very much on how organizations can think about managing the risk and dealing with some of the challenges which are coming down the line in terms of AI. And we're going to be very focused on the practical elements of this. So although we'll cover some of the broader concepts, we're also very clear that there are already clear legal and regulatory risks which organizations face as they roll out AI. And that's why we're so delighted to be today operating as a group, combining both legal and business experience. And so let me quickly introduce the panel we've got here. They're not an entirely random panel. We do work together, so full disclosure on that front. First, we've got Simon Greenman, who's my co-managing partner at Best Practice AI. Simon studied AI back before the last AI winter, but has deep experience, including starting the first AI-enabled mapping company, MapQuest.com, in the States. He is now a member of the World Economic Forum's Global AI Council. Minesh Tana joins us from Simmons & Simmons, where he is the AI lead. And Minesh specializes in technology-related disputes, and he talks regularly on these topics to all sorts of groups and has worked clearly on AI regulation. Jacob Turner literally wrote the book on this matter. He is the author of Robot Rules, Regulating Artificial Intelligence, and is a barrister at Fountain Court Chambers, and he'll talk to some of the cases he's been working on recently in precisely the space. My name is Tim Gordon. I'm a co-managing partner at Best Practice AI. I have 20 plus years of digital transformation experience and governance experience. So hopefully we together bring a unique set of views to the table. Next slide, please, Simon. So we believe that our core thing that brings us together is that trust is the absolutely key to gaining sustainable competitive advantage in the world of AI. So it's not just about being good citizens and getting to the right sort of place. It's also, if you want to build businesses and organizations that are going to succeed and deliver and win in the age of AI, you absolutely need to win on the trust front. So without further ado, I'd like to pass this over to Simon to talk about why AI governance matters.
Well, good morning, a pleasure to, or rather good afternoon, a pleasure to be here. As Tim said, there's sort of a balance between the narrative around AI for good, but also the other side of it, there's something of a storm brewing, and all of us are familiar with the headlines of AI is biased, we have threats of existential risk, robot killers, that sort of thing. And the question seems to be, can you see my slides, by the way?
Yes.
Okay, very good. So the question is why? Why is there this sort of narrative going on about the risks of AI? And in many respects, it relates to the nature, the intrinsic nature of the technology and of AI. And so if we take a look at what AI is, basically machine learning, which is sort of the latest incarnation of AI, identifies high dimensional patterns in large data sets to make predictions. And it's all dependent upon having large data sets to teach the machine learning systems what different objects and items are. So in this particular slide here, what we're saying is to teach a machine learning the difference between a cat and a dog, you have to show it lots of labeled examples of this is a picture of a cat, this is a picture of a dog. And what happens as a result is the software, the machine learning software, figures out the rules itself by learning by patterns in data. So in the old sort of classical programming world, what would happen is you, as a programmer, would type rules, you enter the data, and it would spit out the answer. In the new world of machine learning, you give it data. This is an example of a cat with the answers. This is an example of a dog, and it figures out the rules itself. So it's a really sort of big shift in the way we do software programming. And this in itself creates tension and dynamics. So the challenge is the rules that the machine learning actually creates aren't very obvious. Now, on the left here, what you can see is a decision tree around mortgage decisions. Are you over age 40? Are you in real estate? Do you have a certain income? And this is very intuitive and understandable and explainable. The new world of machine learning in multi-dimensional space, and the space can get up to absolutely billions of dimensions, is much harder. It's a black box, as it's being called. It's much harder to understand. So this presents one of the big challenges of AI and a lot of the underlying tension as to why we need to explain the technology and why there's a regulation. The other side of AI is there's often challenges around its brittleness. If it learns patterns, what happens when it just sees a pattern that it hasn't seen before? And this is an example of Tesla car being summoned. And what it would show is the car driving, and it would be driving down, and it avoids the puddle because it doesn't recognize the puddle as water and something that's safe. So what we see is there's often challenges in the brittleness of AI, and we also hear a lot of cases where safety is compromised because of issues around not being able to recognize things. So moving on to the next section is, Tim, is why AI governance matters. You're on mute, I think, Tim.
It's amazing how we all make that mistake despite 18 months of this job. So look, the focus here really is what does this really mean for a board or a C-suite executive as they begin to look at this new technology? And there's a huge amount of this stuff which often feels quite esoteric to people in sort of management roles. But it's important to remember that if you think about the mix of problems that can come down the track, they are strategic, operational, legal, and ethical. And if you get these things wrong, they often can be pretty high profile. They are challenges both to the organization's strategic ability to compete and to continue to produce good products. Their relationships with their customers are critical. And if you think through the whole series of stakeholder car crashes that could emanate if you get this sort of thing wrong, you can see the endless examples that are publicly available. We can see the risk for brand damage is potentially very large. But all of that can also lead to financial damage. And as we'll discover in a minute, it can also potentially lead to legal damage. So if we think about, next slide, please, if we think about what's happening, we're in a place now where there is a real shift in terms of the technological capabilities. What those do is they lead to, in the top left, there's radical changes in business models and organizational approaches. People start deploying algorithms in all sorts of places to do new things. That changes the stakeholder debate, and the stakeholder debate is getting increasingly terse, whether it's online or in the media, and increasingly in Parliament, and that therefore is leading to increased regulation. And we'll talk in a minute about the European regulation that's coming down the track, but across the world, there is no shortage of lawmakers scrapping to bring new regulation in, which broadly is a very good thing to get things in the right sort of place. And what we're seeing now is this is now leading to legal cases and having legal implications that begin to therefore also feed back into the changes that those organizations are beginning to lead to. So this is getting real, and the importance is accelerating. And if we think about the first big example of that, I'll pass over to Minesh to discuss that.
Thanks, Tim. I'm not sure I'm seeing the right slide, but Simon, are you on the ethical AI slide?
Yes.
Perfect. Well, I'm going to start by talking about ethical AI, because I think one of the reasons we're seeing so much noise and discourse around ethical AI is because there isn't actually that much regulation around AI. And so we've said on this slide that there are more than 200 ethical AI frameworks, and I think that's right. There are a lot of these that have now been issued, including by prominent bodies such as the OECD and the EU. And the advantage of having so many frameworks around ethical AI is that we now have a consensus on what sort of principles comprise ethical AI. And we see this in the context of other labels as well, for example, responsible AI and trustworthy AI. And we've set out 6 key principles on the slide there, and I'll just focus briefly on 3 of those. Explainability is definitely one of the biggest, and we're going to come on to talk about that later and what it means in practice. And this arises out of this inherent black box problem that we have with sophisticated AI models, and it's the need to be able to explain how AI systems are working to the extent you can in terms that are accessible to a layperson. Safety is another big principle, and I think this is more of a substantive principle. It goes to the output of the AI model, and it's really talking about issues such as the avoidance of bias and discrimination, which, as I'm sure you all know, can be a particular issue with AI systems, particularly those using biometric data. And the third principle I think is just worth highlighting is accountability. And having humans in the loop with AI systems. And I think that's important for two reasons. It's important that there are humans that have some element of control when you're dealing with AI. And also there's an element of needing to hold an organization or an individual to account if anything goes wrong with the AI system. So just moving to the next slide. Thanks, Simon. As I said, AI-specific regulation is not yet prevalent. And so there's a slight danger of lulling yourself into a false sense of security by assuming that you're operating in an environment where there isn't much actual legally binding regulation in place. But that is a false sense of security for a few reasons. There are still general regulations which, although they may not have been intended to apply to AI, can nevertheless apply. And the GDPR is a really good example of that. And Jacob will come on to talk about some of the obligations in the GDPR which can apply to AI systems. There are also product liability regimes around the world. They're potentially tricky because they can operate on a strict liability basis where a producer of an AI system could be liable without fault on their part. And we are starting to see some specific legislation around AI in particular domains or sectors. And a good example is, as I'm sure you'll have seen, an increasing trend towards the prohibition of facial recognition systems in certain US states. And as a litigator, I'm always keen to see this, but there are claimants seeking to challenge the use of AI on increasingly novel and creative bases. And again, Jacob will look at some of those cases shortly. And in terms of what's on the horizon, we do expect to see more regulation in the context of AI, and that could be sector-specific regulation. There is currently a law in the UK, not yet in force, but it obliges users of automated vehicles to have insurance in place, and I think we're likely to see more rules like that. And then looking more broadly, we could have general regulation which could apply to AI more generally rather than on a sector-specific basis. And I think the best example of that is the EU's recent draft regulation on AI. So just looking briefly at that over on the next slide. Thanks, Simon. This draft regulation was published only a few weeks ago. It's been coming for a while. President von der Leyen promised regulation on AI shortly after her appointment as president, and she has delivered. And this is a very comprehensive and bold framework seeking to regulate AI in the European Union. Some commentators have said that it's the GDPR of AI. And I think there are a couple of similarities between this draft regulation and the GDPR, which I'll come on to mention. But I think actually this is more akin to almost a product safety law. I think the EU is really concerned about the harm that AI systems can cause to EU citizens. And so what we see is a risk-based approach in the draft regulation. There are some prohibitions on AI, for example, the use of real-time facial recognition systems by law enforcement. But actually, what we see is the majority of obligations in the draft regulation applying to so-called high-risk AI systems. And that's really what the draft regulation covers in terms of its obligations. And high-risk AI systems are defined in some various places in the draft regulation by reference to the domain in which they're used, for example, in a recruitment context, or by reference to certain products in which AI systems are incorporated, for example, medical devices. And there are some really significant obligations on providers of high-risk AI systems. And for those of you who are more from a technical perspective, from the data science perspective, you will look at some of these obligations and probably think they are really serious obligations to comply with. They set very high standards in terms of how you are supposed to deploy these AI systems. It's not the time to look into those in detail here, but we can of course provide further detail if that's helpful. Now, interestingly, the fines for non-compliance are really serious. And that's where there is a similarity with the GDPR. So if you are found to be in breach of those high risk obligations or the prohibitions, you might be facing fines of up to 4% or even 6% of your global turnover if you're a company. So that is a really big stick which the EU is proposing to use as a punishment for non-compliance with this draft regulation. Now, given we've had Brexit in the UK, the regulation doesn't apply to the UK, but as with other EU laws, it has what we call extraterritoriality, and that means it can apply outside of the EU. So I think the most relevant example is if you are a provider of a high-risk AI system, for example, you develop facial recognition systems, and you are based outside of the EU, if you are providing those systems to customers within the EU, then you will still be caught by the regulation, notwithstanding the fact that you are based in a different continent. And so that is a pitfall that developers around the world should be wary of. There's an interesting question about whether the UK will follow suit. I think it's too early to say. There is quite a bit of time for the UK to decide. This draft regulation won't come into force for at least 1 or 2 years, perhaps more. And even when it does come into force, there is a grace period currently of 2 years to allow organizations to be compliant with the draft regulation. So there's no rush, but it'll be interesting to see what the UK does. And at the very least, I think this draft regulation is now starting to focus minds around the prospect of AI systems causing harm and governance around AI. What should organizations be doing in order to manage the risks that their AI systems can cause? So even though it's a comprehensive piece of legislation, it's well worth a read, particularly from an AI governance perspective, because there's some really interesting material in there that can act as a source of best practice or guidance around AI governance. And now I'll hand over to Jacob to look at some of the ways in which AI uses have been challenged.
Thanks, Minesh. Imagine you received a notification from your employer overnight accusing you of fraud, saying that it had detected unlawful practices being carried out by you and terminating your employment contract. You would probably ask for reasons why. You'd probably want an explanation. You may well want to challenge that finding. Well, this was what happened to various drivers for Uber and Ola cabs. They received the notification, or one similar to it that you can see up on your screen, saying that a number of irregular trips had been detected that were associated with fraudulent activities, and that their accounts had been deactivated permanently and irreversibly. Clearly, that is a pretty damaging thing to be accused of. Not only is the livelihood of these people being challenged, but also it presents significant difficulties for them if they want to get other jobs. They may well have to disclose that they had been dismissed for alleged fraud in their future employment application. So it's clearly quite a serious and damaging thing. When they were asked for explanations of why they had accused these drivers of fraud, the companies, Uber and Ola Cabs, replied they weren't going to provide any information because their computer systems had made these detections, and providing any further information on how their computer systems had detected fraud would enable other fraudsters to bypass those systems. So they effectively relied on trade secrecy, amongst other things, in order to withhold this information. Next slide, please. The drivers, needless to say, were pretty disappointed with this, and they didn't agree with these accusations of fraud. So they contacted their union, which is the same union that has represented drivers in some landmark litigation in the English courts. You'll see up on screen James Farrar and Yassin Islam, who were the litigants in the recent Supreme Court case in the UK, which declared that Uber drivers were employees and not just independent contractors. And this union exists to protect its workers, its members' rights, and they're looking to challenge some of the key parts of the gig economy. the first pillar of the gig economy is that there is an arm's length relationship between the workers and the platform companies. And the second pillar is that the gig economy relies very heavily on technology to make decisions about people. And it was this use of technology that was under challenge when these drivers sought to make complaints. They contacted me to help represent them in the Dutch courts to challenge the way that Uber had made these decisions. The reason why this was in the Dutch courts is because the central European entity for Uber is in the Netherlands, and so that was where they were based. And this was the first challenge that was brought under some of the legislation that Minesh has just been discussing, in particular the GDPR. Many of you will, I'm sure, be very familiar with the use of the GDPR in terms of privacy and the types of notices that we see whenever we visit a website asking for our consent to use cookies. But what many organizations are less familiar with are the aspects of the GDPR which enable certain challenges to be made by people whose personal data has been processed using automated means, for which artificial intelligence certainly falls within, whether it's machine learning or simply a traditional automated system where the inputs and the outputs are pre-programmed. As it happened in the Uber and Ola Cabs cases, it looks like they were using machine learning and some quite sophisticated systems. But either way, there would still have been a right for the drivers to demand an explanation. And I'm going to go into a bit more detail later on in our presentation about exactly what the legislation demands. But the key thing to remember at this stage is that people are becoming increasingly aware of their rights to launch challenges against companies. So if your company is using personal data and is making any decisions about using that personal data, using automated means, using artificial intelligence, you are potentially at risk of a challenge similar to that in the Uber and Ola Cabs cases. Next slide, please. We received the judgments earlier this year from the Amsterdam District Court. They said, in terms of Uber, that actually Uber were off the hook because Uber were apparently using humans in the loop. There were apparently only recommendations being made by the systems, with humans able to override those systems in order to make the final decision. Now, that is actually going to be challenged by the drivers, so we haven't yet got the final answer on that. What we will say, representing the drivers, is that those humans were perhaps just rubber stamping the AI decisions. It's not merely enough to have a human nominally in the loop. They actually need to be exerting meaningful intervention. And we'll go on to talk a bit more about that when we come to the governance mechanisms later on in our presentation. Ola, by contrast, weren't able to say that there were any humans in the loop. And so the decision of the Amsterdam court was very much that they shouldn't have been using automated decision making, and that in any event, they needed to provide an explanation of what that automated decision making actually involved. And we're going to talk later on about those explanations and what that might involve on a proactive basis, rather than having to wait until the litigation happens and the costly fines and other regulatory aspects of that. Next slide, please. So in terms of the gathering dangers for businesses, it's not just unions like those representing the Uber drivers, and it's not just the gig economy that this affects. Anywhere that AI is being used is subject to potential legal challenge and is subject to potential regulatory notice being taken of the way that decisions are made using AI. So to give two other examples, the Trades Unions Congress, the largest body of UK unions with 5.5 million members, recently released a report describing the various challenges that could be brought against the use of workplace AI. And we've all seen in the last year, with far more people working from home with the pandemic, that there has been greater use, or at least greater awareness of the use of tracking and profiling programs by employers to make sure that their employees are doing the right thing. And that can be perfectly legitimate, But if safeguards are not put in place, if one doesn't know exactly how and why this AI is being used, that does open you up to challenge. And people are becoming increasingly aware of their ability to bring these challenges, whether it's under the GDPR or under other pieces of legislation. And the final thing I would mention is that there are now law firms which specialize in bringing exactly these kinds of challenges. One of these is called Foxglove, but there are others which are now setting themselves up to bring mass challenges based on algorithmic decision making. I'll now hand over to Tim for the next part of our presentation.
So, approaches to AI governance, we do a lot of work with companies looking at how do you actually put in place the right mechanisms, compliance steps, and alike to ensure good governance. We won't have time to go into a lot of details, but I'll give you a few highlights of some companies that we've seen and the approaches that they're taking. As Mark Benioff, the chairman and CEO of Salesforce said, and I think he says this very well, the fourth industrial revolution starts with one very important point, trust. And the fourth industrial revolution includes technologies such as AI, blockchain, autonomous vehicles, and we see a huge convergence of these technologies that impact in the world. But without fundamentally trust, and that's trust amongst customers, trust amongst suppliers, trust amongst your employees and staff, trust amongst regulators and society around the use of these technologies, it is very difficult for companies, especially big technology, to be in a position of growth over the long term. So trust becomes the cornerstone and the key to around the use of AI as we look into the future. And we see this evidenced by Microsoft, and Satya Nadella, the CEO of Microsoft, says building trust is crucial. And it starts with us taking accountability being one of the key AI principles that Manesh mentioned earlier. We don't have time to go through all of their practices, but a couple of things that they've done very clearly on the right here. First of all, they've spelt out across the organization their 6 AI ethical principles, from fairness, reliability and safety, privacy and security, inclusiveness, transparency, and accountability. And those principles are discussed and implemented far and wide. And then this is part of their cultural change program, is how do you get those principles actually turn into practice? And Microsoft's got an interesting game called the judgment call game, which is basically a game for cultivating stakeholder empathy through scenario imagining. Imagine how technology would impact different groups and bringing that life to people who might not necessarily be sensitive to it. And it's really quite something, that the judgment call game. Another example of best practice in AI governance is Salesforce. And Salesforce, as we know, is an enabler. It has hundreds of thousands of customers using its technology platform. So Salesforce is really saying, how do we enable our customers to have good AI governance with the responsible use of technologies? And they have a number of things. They again, on the right, spell out their principles. But then how do you turn those principles into practice? A lot of their technology platform is built with ethics by design. So into their technology platform, you have things like explainability features, which allows their customers to relatively quickly and easily explain how models work, i.e., why is a model making this decision? And we will talk more about explainability at the end. We really like what Deutsche Telekom is doing. Deutsche Telekom, which has a net promoter score, i.e., how likely are its customers to recommend it, has a net promoter score higher than Google, which is pretty amazing. But what they recognize is fundamentally the relationship with their customers is built on trust. So they see trust as a strategic necessity. So they've committed to a program of AI governance and compliance that it is really 9 lessons that they've walked through. We're not going to have time to go through it, but it really demonstrates openness. It demonstrates AI responsibility by design. There's a huge elements of training amongst staff to be aware of AI issues such as bias and alike. So overall, what we see when we look across governance programs across the world is really there are 8 things that need to be done for responsible AI governance. The first thing is it's very important to have a high-level appointed leader in an organization that is seen as the champion of responsible AI governance. AI, number 2, is cross-functional. It's not just something in technology, it's not just something in legal, it's not just something in business, it's cross-functional. And teams working together need to create ethics codes and policies. And those cross-functional groups need to ensure the company-wide adoption of these policies. Number 4 is by design, across the life cycle of AI, data model is making sure that data privacy, bias, and fairness, explainability, and transparency are built into process. Number 5, education. Number 6, ensure policies are extended to third-party providers. Make sure your AI suppliers are following responsible AI practices. And what we think is the cornerstone, as I turn this over, is ensure explainability and transparency with all stakeholders, especially customers and regulators. So explainability, we very much believe, is the cornerstone of trust in AI. Jacob.
Thanks, Simon. I mentioned earlier that the GDPR gives rise to rights to explainability, and I think it's useful to have a very brief look at exactly what is demanded under Articles 13 to 15. These talk about meaningful information on the logic involved needing to be provided whenever there is automated decision making about an individual, which has a significant effect on them or which has a legal effect on them. So this isn't going to apply, for example, if you have purely financial modeling AI or if you have AI being used in a factory. But if AI is being used in other contexts, and in many cases it will be used in a context where information about individual people is being processed, then this will be caught by the provisions of the GDPR. Meaningful information about the logic involved. What does that actually mean? Now, those of you from a technical background will know that AI systems or machine learning systems do not use logic in the same way that traditional deterministic computer programs or expert systems might do. They simply don't function on a logical basis, as Simon alluded to earlier in the presentation. So we have a difficulty here in terms of complying with this legislation. And part of the reason why this difficulty arose was that this wording was not designed for modern machine learning systems. In fact, it was taken from the 1995 directive. And although Simon might have been working on AI back in 1995, certainly the legislators in the EU were not thinking about AI in those days. So what we have is a really outdated piece of legislation that's now being applied to modern technology. And where you have a system that has aspects of black box reasoning, it can be really difficult to know exactly what this means. Next slide, please. Fortunately, we are now starting to see some guidance coming through from regulators as to how organizations can comply with their obligation to provide meaningful explanation about the logic involved. And some of the most advanced guidance comes from the UK regulator, the Information Commissioner's Office. They have spoken about how there are 6 types of explanation which are up on the screen. These include a rationale explanation, the reasons that led to a decision, responsibility, so talking about who is involved in the development and management of the AI, which would include humans being in the loop, and descriptions of where humans are in the loop and exactly what their role is. Precisely the kinds of information that Uber and Ola Cabs, in my case, failed to do, or at least failed to do until they were ordered to do so by the court. The data explanation is very important, and this is actually something which has been very much picked up by the European legislature in its new draft AI regulation that Minesh was talking about earlier. So descriptions of the data sets that were used, what kind of training has occurred with those data sets, the models that have been built based upon those data sets. A fairness explanation is also important. So this includes steps taken to make sure that systems are not biased. And we've seen many examples of biased systems coming into the press in recent years, whether it's the Apple credit cards discrimination against women by giving them lower credit limits, or the Amazon hiring algorithm that discriminated against women and ethnic minorities. There are many examples of this occurring, and these things may be latent in data sets that the programmers are unaware of. Safety can be a relevant type of explanation, although that won't be necessarily important for all organizations if there's no physical aspect of the programming being used. And then finally, the impact on stakeholders and the wider society. So what the ICO have done is they've given a menu of ways in which organizations can comply. And one of the things that we as a group, Minesh, Simon, Tim and I have been doing is helping organizations to implement these types of guidance in a practical manner. Minesh is going to talk more to that now.
Thanks, Jacob. And Simon, if we could go on to the explainability statement slide. So the initiative that Jacob was referring to is essentially an explainability statement that an organization will produce. And what does that mean? Well, it's a short document, relatively short, 5 to 10 pages, and it's aimed at explaining how an organization's AI system or architecture works. Now, it's a document which is intended to be drafted in non-technical terms, so it's accessible to everyone. And it's also intended to cover the 6 types of explanation that Jacob just referred to in the ICO ensuring guidance, and also to be compliant with the GDPR explainability requirements that Jacob was just discussing. Now, the obvious reason we're helping organizations to do this is because there is a legal requirement to be able to explain how your AI system operates in certain circumstances. As we also explained earlier, explainability is a really important component of ethical AI. But what's not absolutely clear yet is how you go about explainability, what you say, how much you say, which of the components of your AI system you need to talk about, and how much detail you need to provide. So what we've done is a lot of thinking around exactly what you need to be saying about your AI systems. And what we have is a long form statement, which is essentially a really detailed questionnaire seeking to elicit the type of information that we think should be included in an explainability statement. Again, reflecting that ICO Turing guidance and the GDPR requirement. And what we do is we go through that with you and together create a short form statement. And that is a statement which is intended to be public facing. It can be given to data subjects if they request how you're using their personal data in the context of your AI systems. It can be given potentially to regulators should that become necessary. And we also think that it has a commercial benefit. It shows stakeholders and other parts of your supply chain that you're thinking about your use of AI, and ultimately that you're trying to be as transparent as possible in your use of AI. And we think, and this is really a key takeaway, is that the more explainability you have around your AI systems, the further towards implementing good AI governance. And I think we're going to finish on that note there and open the floor to any questions.
So reading the questions, thank you guys. Question from Hannah G. Cock. Would you advise software to have built-in explainability features like Salesforce on top of an explainability statement? Minesh or Jacob, do you want to come in on that?
I guess instinctively, it depends on how effective and how much detail there is in the kind of inherent explainability tools that are being used. And we're aware that there are various tools that can be used in AI systems. So there's Shapley and Lime that are good examples of how to interpret are operating. But I think the danger with those is they're not very non-technical. And I think the idea about an explainability statement is that you can really start to explain things in a non-technical way and cover all the points you need to. So I think I would say, yes, instinctively, it's still worth having an explainability statement.
Jacob, anything to add to?
Yes, I agree. I think the software add-ons and the things that one can build in are extremely useful from a technical perspective, but what regulators will be interested in is the public-facing aspect, and whether a meaningful information of the logic involved can be given. The word meaningful, I think, is important because it means that the information needs to be understandable to the average person, or at least whoever it is that's being affected. And so whilst a data scientist might be able to understand what a software-based explanation would entail, having a statement which sets it out in clear English or whatever language one might be using is something that regulators would expect to see, and absence of which certainly puts the organisation at risk of potential litigation or regulatory action.
Okay, so the questions are now piling up, so I want to jump through them quickly. Mahesh Haraharan asked, how does the explainability statement keep in sync with changes in the model on an ongoing basis? Simon, do you want to?
Yeah, I mean, it's a great question, but I think the reality is, and the first point I want to address is the previous one, is explainability needs different things to different groups. So what data scientists and engineers might view as explainability would be different from business people, lawyers, and regulators. So whilst, you know, you can use tools such as explainability, there's a lot of tools out there like Line to do explainability that might make sense for a data scientist. As Jacob and Nesh said, putting a layer and putting that into context, into language that's understood by the layperson and the regulator is very, very important there. And what was the question, Tim? Sorry.
The question was, how does the explainability statement keep in sync with changes in the model on an ongoing basis?
So on that basis is, if your model is fundamentally changing, then you will naturally need to update your explainability statement that is published to the outside world. You know, if there are minor changes that don't materially impact that explanation, then obviously that doesn't need to be done.
Okay. Jacob, any other thoughts on that?
Well, I think the key point is to think about one's audience in this, and the focus from regulators is on the average person. So I agree with Simon's point there.
I mean, one thing, I'll just use this chance as well, just to make a quick plug, which is we're doing an open session tomorrow at lunchtime around explainability statements. A lot of this stuff is very much still in progress, still being developed and still growing. So you know, the broader the conversation on this, the better. So do please join us tomorrow. I think it's 1 o'clock, a session we've got, and we'll try and get people up on stage to give their views and thoughts on this as well. Robin Carpenter asked, and just crossing the last question, what practical governance actions would you advise an organization to take in the next 12 months?
I'm happy to.
Yeah, but go, Jacob.
Well, I was going to say, firstly, just by way of add-on to the last point, in terms of changes to the model, an explainability statement would cover, ideally, the way in which model changes are made, so that there is a forward-looking aspect of it. But the second point is it's a living document which needs to be updated from time to time when changes are made, and that doesn't necessarily need to be each day or each month, but on a periodic basis. That is how one would keep it up to date, just as with any other type of internal policy that needs to be kept up to date based on what the business is doing. In terms of the steps for the next year, complying now with the explainability requirements, making sure that you have governance systems in place, making sure that all areas of the organization understand how the AI is being used, that it's not just an issue for your technical team, for your CTO, for your data scientists, or indeed for your procurement team if a lot of your AI use is outsourced, but rather this is something that all areas need to be involved in. That's the technical aspect, that's your compliance team, that's your legal team, and it's your management. There needs to be investment from all of those sides, and they need to work together to try to make sure that there are the documented internal governance structures. It's not just important to have these things, it's important to write them down and to have a demonstrable audit trail that a regulator can see, or that if there is a legal challenge, which obviously one hopes there won't be, but if you're in a customer-facing organization, that's always a possibility. If there is a legal challenge, you want to have all of your ducks in a row. The best thing to do is to start creating those governance structures now, rather than waiting until the potential regulatory or legal challenge comes, and then being in a scramble to try to create them looking backwards.
And I think we're sort of running out of time, but just to sort of close on that, just reinforce that point, which is there's a whole bunch of things that could be done. And we touched on some of them in the slides in terms of particularly that slide with the 8 things you need to do. That can be quite a mouthful in terms of organizations trying to get involved in this. We do think explainability statements are one of the ways, though, in which an organization that's doing this could really get its head around both some of the stuff it has to do for regulators and potentially with the sort of some of the legal threats lurking in the undergrowth that Jacob's mentioned. But also it's important in terms of reaching out internally to stakeholders to clarify what the state of play is, where the strengths are, where the weaknesses are. One of the things we're discovering as we do explainability statements for organizations is we're discovering some of those challenges and bringing those to the fore. Look, thank you very much, everyone, for your time. It's been lovely having you. Enjoy the sun wherever you are around the world. And do please join us tomorrow for further conversation on this. Thank you very much. Bye-bye.